Welcome to a new episode of Eye on Academia, a podcast presented by the James G. Martin Center for Academic Renewal. The Martin Center is dedicated to the reporting and analysis of higher education events, policies, and trends. I'm Jay Shallon, the host for today, and a senior fellow with the Martin Center. Higher education's influence on the intellectual life of the nation is hard to overestimate. It's where most new ideas are conceived, incubated, and spread to the rest of the general population. If you don't like the direction the nation is moving, in any aspect, political, cultural, educational, and so on, chances are you have academia to thank, at least in part. Therefore, our colleges and universities need eyes on them, so they cannot operate in secrecy and use their influence to promote undesirable ends. We hope this program serves just that purpose. No event in the last few months has been more important for the future of higher education than the Supreme Court decision in Students for Fair Admissions versus Harvard. The court sided with the plaintiffs in their attempt to end the inclusion of race as a factor, and often a deciding factor, in college admissions processes. On its face, it was a big win for meritocracy. But the decision may not be as clear-cut as it seems, and there is a huge racial preferences apparatus inside of academia that is likely to find ways to undermine the new decision. And that apparatus has plenty of allies outside the academy. In fact, just yesterday, on August 14th, the Biden administration came out with a list of guidelines that do not bode well for how the decision will be handled. Our panelists today are the usual suspects: Martin Center President Jenna Robinson, editor Graham Hillard, and lead researcher Shannon Watkins. Since this is such a complex topic, let's start the discussion with some background and context. Shannon, could you give us a summary of the affirmative action in higher education admissions issue, which is really what we're talking about, with brief arguments in favor of and against?
Yeah, certainly. So affirmative action can be summarized as giving preferential treatment in college admissions decisions to different demographic groups. And there are arguments in favor and against. Those in favor can be roughly broken down into two. First is the remedial argument or the reparation argument. So due to a long history of past injustices, minorities, particularly Black people in this country, were unjustly held back and discriminated against. And many view affirmative action in higher education as a way to help make up for that. Many argue that the effects of those years of discrimination still have a strong hold on society, and affirmative action, again, is seen as a way to compensate these groups for these past injustices and help close demographic gaps, particularly in admissions and in academic achievement. And especially higher education is seen as a gateway to prosperity, both economically and socially. And that's why there is such a strong focus on college admissions. And racial preferences in higher education is considered especially necessary because, again, leaders in both politics and in the business world are going to be coming from graduates of colleges and universities. The second main argument in favor of affirmative action policies is that racial preferences helps boost racial diversity, which schools should strive for because of a purported educational benefit that comes from this sort of diversity, not just racial, but gender, etc. Diversity here is considered an academic good. Some argue because it exposes students to different ideas and experiences. Others say it prepares students to live in a diverse society, promotes understanding, etc. Schools, again, will often point to this rationale when they're employing affirmative action policies. Now, there are many objections to the use of racial preferences in college admissions. For one, many say it's fundamentally unfair. It's not fair to judge people on immutable characteristics instead of on their merits. It's anti-meritocratic. And often others will point out that these policies don't necessarily help the descendants of slaves. It helps affluent Black people. It helps immigrants who weren't around when these past injustices were occurring. And I think a very compelling argument is that these policies don't really help the people that they're supposed to help in the first place. For one, it perpetuates this idea of soft bigotry of low expectations, this idea that certain groups need a leg up in order to compete with their peers, that they can't just do it based on their own competence and ability and on their own merit. And this in turn feeds stereotypes. If people know that medical schools are aggressively employing affirmative action policies, they may not be able to help but think in the back of their mind, is this doctor who I'm seeing, were they admitted into medical school because of their ability, because of their knowledge of the material of medicine, or was it heavily due to because of their race or their gender? This doesn't help anybody. Another way, very compelling argument I've heard that's fairly talked about is the theory of mismatch. Affirmative action policies will put students, admitted students, into classes where they're not at the academic level of their peers. And so what we'll see is that these minority students who are admitted are at the bottom. They're the most underperforming of their classes. Richard Sander and Stuart Taylor have said that mismatched students, as they call them, are twice as likely to be derailed from pursuing a doctorate and an academic career. They also say that Black law school grads are currently 4 times as likely to fail the bar as their white counterparts. Again, this is just not helping the people that they're allegedly helping. In addition, these sort of policies pit people against each other. It fosters resentment. It forces people to hyper think about their identity group. And finally, many have raised the question, is this sort of diversity really of an educational value? Racial diversity, gender, doesn't necessarily equate with a diversity of thought, of ideas, or of perspectives on different issues. Those, Jay, are the main arguments in favor and against.
Okay, thank you, Shannon. And Graham, you seem to be up on the history of higher education, affirmative action court decisions. And so could you give us kind of a blow-by-blow description of how the status quo came to be before Students for Fair Admissions?
Of course. So the phrase affirmative action, as some of our listeners probably know, came from a 1961 executive order by President Kennedy, in which he stated that government contractors should take affirmative action to ensure that applicants are employed without regard to their race, creed, color, or national origin. Now, ironically, that's exactly the opposite of what the affirmative action regime in this country eventually turned into. And that happened largely because of subsequent executive actions, especially by Presidents Johnson and Nixon, as well as a series of Supreme Court decisions that permitted increasingly preferential treatment for some politically important groups. I'll just name 4 of those very quickly. Regents of the University of California v. Bakke was a 1978 case that considered the general constitutionality of affirmative action programs on campus. There was a white man named Alan Bakke. He was denied admission to, I believe, UC Davis's medical school, despite having higher test scores than some minority students. The court tossed universities' quota systems, but ruled, and this is crucial, that colleges have a, quote, compelling interest in having a diverse student body because of the supposed educational benefits of diversity. This is what Shannon was talking about a few minutes ago. This is all traceable back to that Bakke 1978 case. So one of the holdings of the Bakke decision was that race or ethnic background could be deemed a plus in a particular applicant's file. In 2003, the court took up the cases of Gratz v. Bollinger and Grutter v. Bollinger, which looked at the University of Michigan's admissions points systems. Michigan was giving every applicant a score, and racial minorities got an automatic 20-point bump, and the court ruled in Gratz that wasn't allowed. Race had to be considered on an individual basis rather than a group basis. However, in Grutter, the sister case, that 2003 court upheld affirmative action in principle as long as race was considered in a quote-unquote narrowly tailored way. And I should mention, too, that was that famous case in which Justice O'Connor declared that none of this would be necessary in 25 years. The last case I'll mention is Fisher v. University of Texas, which was basically a failed attempt to overturn Bakke and Grutter in 2016. The University of Texas automatically admitted in-state applicants in the top 10% of their high schools. Then they used race as one factor when deciding whom else to admit. A white student who had been denied admission sued, and the court held that schools could still use affirmative action to make diverse student bodies if all else had failed, if no race-neutral alternatives had sufficed. So the big overall story here is that while the Supreme Court has consistently narrowed the use of race in admissions, it's never backed off that original 1978 finding that universities have a compelling interest in racial diversity. And crucially, Students for Fair Admissions v. Harvard and UNC doesn't overturn that 78 ruling. It doesn't overturn Bakke. It doesn't overturn Grutter. Now, in his concurrence, Justice Thomas said in June that Grutter is overruled for all intents and purposes, but concurring opinions are not binding. And I think that Justice Thomas may be misreading the situation. We can discuss, and I'm sure we will, whether optimism or pessimism is warranted going forward, but the court definitively did not strike down any use of race in admissions. And as long as that door is open a crack, colleges are going to squeeze through, as we saw earlier this week with the Biden administration's guidance.
All right. Well, thank you, Graham. Jenna, you're kind of up on some of the responses and everything. And also, could you tell us about, we're arriving at the specific Students for Fair Admissions case. Could you give us a little wrap up about that?
Sure. So back in 2014, Students for Fair Admissions, which is run by Ed Blum, filed suit against Harvard and UNC, alleging that their undergraduate admissions practices violated Title VI of the Civil Rights Act of 1964. And they had a couple of specific complaints against Harvard and UNC. They said that Harvard violated the act by discriminating against Asian Americans in favor of white applicants, and that UNC violated the Civil Rights Act by using race to give significant preference to minority applicants to the detriment of both white and Asian American applicants, while ignoring those race-neutral alternatives that Graham mentioned just a moment ago. And they said specifically that Harvard imposes what they called a soft quota of racial balancing that artificially depresses the number of Asian applicants that were admitted. And also that Harvard's individualized admissions files showed that Harvard admissions officers consistently rated Asian American applicants as a group lower on positive personality traits, such as likability, courage, and kindness. So in Harvard's case, the discrimination against Asian Americans was really very acute. At UNC, they went through the admissions practices and showed that racial preferences were more than just a tiny bump. It was a significant thumb on the scale in several places in the admissions process for minority applicants. So in the decision, which was written by Justice John Roberts, who wrote for the majority, The decision ended overt racial preferences in admissions, but it, as Graham said, it does not, it doesn't end everything. It does not mandate total race blindness in the admissions process. And Roberts cited a couple of reasons for the decision. First, he said that the educational benefit from diversity is too amorphous a goal, and that the ways that universities are getting to that, the alleged ways that universities were getting to that diversity were not clearly linked to the educational goal. And so I think that actually goes a little bit of the way towards addressing the argument in Bakke, because the court is rejecting, they're saying they cannot make a decision based on that. It's too amorphous. They can't show that educational benefit is happening. The court also ruled that the race-based admission systems as practice used race as a negative, which is outlawed, and that race-based admission systems as practice allowed race to operate as a stereotype. So for those reasons, they ruled in favor of the plaintiffs. They also emphasized that the Constitution protects individuals and not groups. Let me read a quick quote from the decision. One of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person to be judged by ancestry instead of by his or own merit and essential qualities. But when a university admits students on the basis of race, it engages in offensive and demeaning assumption that students of a particular race, because of their race, think alike. And so that speaks to the court's concern that universities were trucking in stereotypes when they were using race in admissions. Roberts also pointed out that the university's use of race in admissions had no logical endpoint, as the Grutter decision required. When Harvard attorneys were asked, when are you going to stop this program? They had no answer. They were going to do it in perpetuity. And Roberts said tellingly that eliminating racial discrimination means eliminating all of it. But as it's already been noted, he did leave the door open a crack for university shenanigans, which I think we should all expect to happen. He said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so, there is still that opportunity for universities to use race if they so choose. And Harvard has made it really clear that it's going to test the limits of the new decision. One of its first actions was to make this essay prompt mandatory for all applicants. Here it is. Harvard has long recognized the importance of enrolling a diverse student body. How will the life experiences that shape who you are today enable you to contribute to Harvard? So it is priming students to talk about race. I mean, this is more than a wink and a nudge. This is saying, please, here's your opportunity to allow us to discriminate. And this is despite Roberts saying, really, no, you shouldn't do this. He said, despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime that we hold unlawful today. He said, if you can't do it directly, that doesn't mean you're allowed to do it indirectly. So I think we can really expect this to be relitigated, especially at Harvard if they're using an essay prompt like that. But the Biden administration, in some ways, it's not as bad as the Harvard essay prompt, but it does back up Harvard's actions to some extent in its new guidance. The guidance says universities may continue to embrace appropriate considerations through holistic application review processes and, for example, provide opportunities to assess how applicants' individual backgrounds and attributes, including those related to their race, experiences of racial discrimination, or the racial composition of their neighborhoods and schools, can contribute to their success at the university. And so the Biden administration is saying, yeah, go for it. Try it out, see if it works. And the guidance also suggests that universities might want to dumb down their admission standards. They might want to end standardized testing, eliminate certain minimum course requirements, and do other things to kind of get around this ruling. UNC, on the other hand, has gone in the opposite direction. The president of the UNC system said immediately that, we are closely reviewing the decision and they're going to follow the law. The board of trustees chair of UNC Chapel Hill said the same thing. He said, on behalf of the people of our state, we will work with the administration to ensure that the University of North Carolina at Chapel Hill complies fully with today's ruling from the nation's highest court. We intend for America's oldest public university to keep leading. And they, in fact, have eliminated all of their essay questions that would have been a nudge for students to talk about race. Their essay questions are now all open-ended, and none of them, I think, will need to be relitigated at all. That they have very appropriate essay questions now. But they also did some other things. They made the applications so that the person reviewing the application is now blind to the person's race, unless the person mentions it in an essay. There's no way for the reviewer to see what the applicant's race is. And they've also started working through what that's going to look like in the graduate admissions process. In addition to that, the Board of Trustees passed a resolution, a non-discrimination resolution on July 27th, kind of backing up the court's decision and going further in some ways. It said that the university will not unlawfully discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, etc., for its admissions, its hiring, and its contracting. And it also specifies that the university shall not establish through application essays or other means any regime of or encourage heuristics or proxies premised upon race-based preferences in hiring or admissions. If the university considers the personal experience of applicants for admission, each applicant must be treated based on his or her experiences as an individual, not on the basis of race. And so I think that, we can see two different responses in two different directions here with Harvard and with UNC. And so it's gratifying to see that there is a way for universities to comply. UNC has kind of laid out a pattern. They haven't figured out everything yet. Like I said, they're still working on graduate admissions, but in general, I'm much happier about UNC's response than Harvard's.
Yeah, if I can just jump in for a quick follow-up. There was a terrific piece in the New York Times yesterday. I actually have it in front of me. The piece is "Colleges want to know more about you and your identity," and the word identity is in scare quotes in that headline. But what they've done here is that they've assembled new identity-based admissions questions from 24 elite colleges, and some of these are just hilarious. And in their explicit attempt to game the system. So, for example, Johns Hopkins is now asking, tell us about an aspect of your identity or a life experience that has shaped you. That's actually not that terrible. Some of these are far worse. Duke says, feel free to tell us any ways in which you're different and how that has affected you, which may as well read, feel free to tell us your race now, right? But my favorite, I'll just mention this very quickly. My favorite is from Dartmouth College, which says in its essay prompt, let your life speak. Describe the environment in which you were raised and the impact it has had. So Dartmouth applicants are now letting their life speak and hoping that friendly progressive admissions counselors are listening.
Oh,
Yeah, I think these essay questions are key to understanding what's going on here and key to knowing in the future who's discriminating and who's not, because obviously students should be able to write in their essays about the most important thing in their life, no matter what it is. And if race happens to come up in that's fine. But universities really should not be prompting or priming students to write about race so that they can then go back to doing the very thing that they were doing before, giving everybody a +1 if they are a minority applicant or whatever they're going to do. And so I think that going over these essays and looking at these essays it shows you exactly where we're going to see this relitigated in the future.
Well, I think we have a new industry as far as essay writers goes. But I think one thing that this might be showing is there's kind of a public versus private divide here. UNC, the public institution that is very much, they have to obey the legislature at some point. They are complying. They're all in, and it may be because of their governance system, which it comes from the legislature down to the board of governors, down to the board of trustees, in which these people are really responsible to the people. On the other hand, Harvard, with, I don't know, its $40 billion endowment, pretty much is going to do what it wants to do. And all of the other schools mentioned, Johns Hopkins, Duke, Dartmouth, they're all flush with money. So I think that there's kind of a public-private divide going on here. Now, how do we think, even in a well-meaning institution like UNC, how are we going to be able to know whether?
So I think something really key is that UNC is going to have to start mandating standardized testing again. We are still operating in a regime, back from COVID, where test scores are optional. And I think that it's time for that to end. If we want to know that UNC is really using merit, it's time to restore the ACT and the SAT as mandatory parts of the admission application, and then making those things transparent so we can tell that there aren't these huge discrepancies between the scores of students who've been admitted who are a minority and who are not minorities, and that can really keep them honest. UNC is also, as part of that resolution that I just mentioned, required to report on any lawful discrimination that they're doing. And the reason that they're still allowed to do some lawful discrimination is because, of course, they're discriminating in favor of North Carolinians. They sometimes, for certain programs, discriminate in favor of veterans, and all of that is part of the North Carolina law. And so, but we should get some reporting out of that resolution that I think will also be useful.
So are we going to see a drop in minority students at elite institutions, do you think?
Not if by minority students you mean Asian Americans.
Oh, okay.
In a meritocratic system, I think we'd see a drop in white students and a rise in Asian American students, which may produce some interesting political outcomes. But certainly, if we see the widespread reinstatement of standardized testing, we may see groups who have historically not done as well on those tests begin to decline as a percentage of incoming freshman classes.
Right. I think we also have to remember here that this ruling really only affects a tiny minority of institutions. Most institutions, for all intents and purposes, are open admissions. You have to have a pulse, you have to have a driver's license, not even an identity card, and a GED, and they'll let you in, right? You don't have to do much. You can get into a huge majority of colleges in the US. And so this really is just about elite private institutions and flagship institutions in some states. Not even all flagships have been using race in admissions. And some flagships that are struggling are becoming more and more like open admissions institutions. And so it's an important ruling. It absolutely matters, but it really is just about that minority of elite institutions.
Okay, and so what are some of these? There are some loopholes out there, some proxies, whatever. But so far we've had mentioned schools can drop SATs, and they can do certain things to get, the essays are another way to get around the ruling. Are there some other loopholes out there?
I wouldn't call them loopholes, but there are other strategies. As we've seen with Texas, they admit the top 10% from every high school class. And while that does get you to the end point of a more diverse student body, I still wouldn't call it a loophole, because it is applied across the board, regardless of race, in the same way to every person who is admitted. And so it's not discriminatory on its face. And so I think that's what we really need to be on the lookout for, is things that are, still allowing universities to discriminate.
So I think that, some of the proxies for race are more complicated than others. So for example, we might see universities begin to increase their outreach to high schools in certain zip codes, because they think that zip codes or residents, which I should mention is easily gamed by wealthy people with time on their hands. Zip code residents can be a handy proxy for race. I actually have a piece coming out in City Journal later today about 2 new reports from the President's Alliance on Higher Education and Immigration. And these reports, explicitly urge colleges to begin to recruit more first and second generation legal immigrants and illegal immigrants. And they lay out very clearly, if you do that, that is going to get you the diverse class that you want, despite the Supreme Court ruling. So I think in some cases, we're going to see efforts to make proxy substitutions be relatively inoffensive and harmless, and others are going to run afoul of the law in, as Jenna said, future litigation.
Well, it sounds like very targeted recruiting, which once again, that can be considered a form of discrimination, that no, you're not recruiting people from this zip code, you're recruiting people from this zip code. It's still kind of like, it may be inside the law, but the intent is to kind of beat the law. Yeah, that's certainly a possibility.
I don't know. I'm going to push back on the recruitment a little bit, because as long as you hold the line on your admissions policies, if you're serious about what your admissions policies are and you have minimum admissions requirements and minimum course requirements, and you stick to those, and all you have done is through your recruitment is to identify students who are qualified academically to come to your institution who wouldn't have known about it otherwise, then I think that's okay. That's giving them an opportunity. But if you extend that special recruitment to letting students in without the academic background and the academic preparation of their peers, then that's when I think it strays into being problematic.
And another thing, I think it was already mentioned, there is the possibility that this is not the last in its line, that future lawsuits are going to come along and maybe incrementally shift the bar just a little bit more. Like this one, it's not the final say. Do you think that's going to happen fairly soon, or?
I mean, Harvard was stupid enough to have people in its admissions office giving Asian students across the board, bad personality scores. And so, yeah, I expect Harvard, when it gets the answers to its essay prompt that I just read, to read that essay prompt with identifying a student's race in mind, and then give them extra points if it's one of the races that they want to recruit for. I just think that Harvard, given its behavior in the past and its attitude about this ruling, that we can expect that its responses to that essay to be equally foolish.
Jenna, I just want to, can I follow up with what you just said? What do you think then would be, after that is relitigated, what's the solution?
I mean, I think that I love UNC's resolution, specifically stating that you cannot use essays as a proxy. And so I think having open-ended essays is the answer for that. Now, I don't think that it's really the Supreme Court's place necessarily to tell, to kind of like micromanage college essays. That seems really unnecessary. But I do think this is the time for, at public universities, legislatures and boards to step in and say, you guys are going to have minimum admission standards. You are going to mean it. And your essay questions are not going to be leading questions that prompt students to talk about their race.
My ideal solution would be to get the government totally out of the business of backing student loans, and then let colleges do whatever they want. And if some college wants to carve out a market share as the racist college that openly discriminates against applicants, by all means, it's America, let them do it. But as long as the federal government's going to be in charge of ultimately paying for everybody to go to college, whether through loans or grants. I think it's appropriate for the Supreme Court to say, knock it off with your racist admissions policies.
No, I think that's absolutely true. If colleges were not funded to the extent that they are by federal money and state money, then we wouldn't care.
I've often wondered, as a matter of fact, why Harvard, with its billions, doesn't just say, no more student loans, no more federally backed dollars, and we're going to do what we want. I wonder if they're just trying to, be social justice warriors and press a political point.
I think with Harvard, some of the money that they want to continue to have access to is the research dollars.
So this kind of comes around to the accreditation problem here, because they're the gatekeepers as far as letting schools get federal funding. Do you think they're going to jump in line with this new ruling, or, are they going to be one more, what way that the diversity proponents can throw a monkey wrench in the drive to make college admissions meritocratic?
You should take this one, Graham. You just wrote about accreditation and DEI, so I think you should.
Yes, I'm just trying to think. I don't know that I've ever heard of an occasion in which accreditors weighed in on universities' admissions processes. Nothing is coming to mind. Certainly, I didn't see that in any of the research I just did for my National Review piece, which to our listeners, please read. I think that there is a sense in which, as I and others have written about, there's a sense in which accreditors are pushing campuses to the left, or I should say maybe ratifying the leftward proclivities of campus administrators and faculty. But I'd be surprised to find an accreditor weighing in on the specific wording of an admissions essay prompt, for example. Jenna, am I wrong?
No, from what I've seen, there's really nothing in their guidelines that would justify them doing anything with admissions. I mean, that's not to say that one of them won't. I mean, who knows? But I don't really expect it.
If it's going to happen, it'll happen in response to what Chapel Hill has just done, with their the policy we've been talking about. I guess I could imagine Sachs writing one of their letters of complaint, saying, how dare you not discriminate on the basis of our preferred groups?
Yes, I think UNC has gotten used to Sachs nasty grams and knows what to do with them.
So last year, I wrote an article about the accreditor for UNC Chapel Hill School of Journalism. And the School of Journalism had received a downgrade rating from the accreditor for not fully complying with its diversity requirement. And I have to take a closer look at what specifically that accreditor requires in order to live up to this diversity requirement. But the School of Journalism says that it will measure progress in the following areas. The one area being most relevant to your question, Jay, is recruitment and retention of diverse faculty, staff, and students. Again, so the School of Journalism is going to measure progress in that area in response to this downgrade from the journalism accreditor, which is the ACEJMC, the Association for Education in Journalism and Mass Communication. It's its full name.
There may be a whole lot of that going on too.
Of course, we have to remember that accreditor doesn't actually hold any real sway. It doesn't guard access to student loans. It doesn't have any power over licensure, because there isn't licensure for journalists. And so I think we should be really worried if the accreditors for medical schools or nursing schools or engineering schools start getting in that game.
It may influence ranking a bit. That would be one area I would think that there might be some harm done to the journalism school. All right, then. We're good. We hope you enjoyed this podcast. If so, Please like, follow, share, rate, subscribe, or even say something nice about us in the comments. And if you want to see the full range of Martin Center content, please visit our website at www.jamesgmartin.center. Thanks again.